Welcome to Limits Exhausted, Texas's personal injury litigation podcast.
Hey everyone, welcome into an all-new episode of Limits Exhausted, the Texas injury litigation podcast with attorney Kiernan McAlpine, the founder of McAlpine Law Firm and a board-certified specialist in personal injury trial law by the Texas Board of Legal Specialization. I'm your host, Mike Leon. You know, Kiernan has served as lead counsel in more than 40 trials and routinely has been handling high-stakes litigation involving 18-wheelers, catastrophic injuries, and wrongful death cases. Today's episode, we're going to be talking about why an 18-wheeler case is fundamentally different than a standard car accident. The evidence, the regulations, to the way these cases evolve, especially once the litigation begins. So, Kiernan, let me ask you, it's good to see you as always. When a referring attorney asks what sets an 18-wheeler case apart from a typical auto accident, like I mentioned, what's the first distinction that you point out?
Sure. Thanks for having me, Mike. So the first thing that I would point out is that when you compare an 18-wheeler case to a regular car wreck case, the most important thing to recognize is that there really isn't any such thing as a regular 18-wheeler case. 18-wheeler cases essentially exist in three dimensions rather than one, where you have with a regular car wreck, really what we're doing is we're assessing liability in terms of, the negligent driver's compliance with the basic rules of the road. Red light means stop at the stop sign, yield right of way, follow from a safe distance, don't go over the speed limit. And all of these sort of basic principles and safety rules that everybody has to follow that they learn when they're getting their license. That's sort of the baseline of a car wreck. And what we're trying to do is establish in a regular car wreck case that those types of rules aren't violated. And while it's true that truck drivers have to follow the same rules of the road as everyone else, there's two additional layers or dimensions to these cases that make them very different. The first would be the federal regulations, the Federal Motor Carrier Act, and the Department of Transportation regulations that govern the trucking industry. And there's a host of rules and regulations that the law requires these companies and their drivers to follow. So looking for ways that the company may have deviated or the driver may have deviated, or both, it's usually both, from those rules and from those laws is something that needs to be investigated. And the third thing is that generally there's company policies. There's safety policies, there's procedures that the companies have that the drivers are required to follow. And we assess the case on that dimension as well. Did the company or in its drivers follow its own policies? Did they operate the vehicle the way that they told themselves that they were going to? Did they follow their own procedures when it comes to incident reporting and incident investigation? All of these things come into play in an 18-wheeler case, and it's a much more complicated situation than a typical standard auto case.
So let's expand on it a little bit more. Let's start with the early investigation stages. You mentioned a couple points there of what's so critical, but you're also dealing with motor carriers, you got federal regulations, you've got company-specific policies. So kind of what tends to happen, take people through what tends to happen in those early stages of these cases.
Sure, yeah. So one of the things that we need to acknowledge when it comes to an 18-wheeler case is that there's a minimum policy for interstate trucking in the United States of $1 million per vehicle. So fleet policies have significant insurance limits, and there's a significant amount of premiums that are being paid by the trucking companies into the insurance company. And what this means is that there's a lot of house money, if you will, to defend these cases. And that process of defending the cases starts immediately. The trucking companies and the insurance company will send operatives to collect evidence from the scene. They'll start interviewing witnesses. They'll see whether the vehicle has captured any data on the vehicles. They will begin the process of discovering and investigating, and as well as shaping their own narrative that they can use to defend themselves. So the process starts immediately, and we need to act quickly in order to ensure that evidence is preserved, logs aren't overwritten, data isn't lost, and that the information that we're going to need in the case gets preserved. So typically we want to send preservation letters, or we want to file suit relatively quickly. I mean, I'll always say that the best preservation letter you can send is a lawsuit, because it's making somebody, you're not just questioning whether litigation will happen, you're starting it. So those are all things that we can use to try to collect information as soon as possible and put us on a little bit more of an equal footing with these companies that are going to be doing as much as they can from day one to start to protect themselves.
Yeah. Can you kind of share an example, obviously without getting into too specifics, but of a past trucking case where something about everything you just mentioned, whether it be driver's logs, maintenance records, onboard data that was collected, it kind of changed the direction of the litigation?
Oh, absolutely. I can still remember a case that happened not too long ago where we had, a clear cut, police investigation, straightforward. Liability facts were in my client's favor. The police officer's report said that. I mean, I could do a whole podcast on the importance and not of crash reports, but generally speaking, it's a clue that we look at to see whether the liability is in our favor. It was. The client told a very consistent story from day one about what had happened in the crash, but the truck driver was telling something, completely different, and was denying liability, as they often do. So after we did a little bit of digging, what we were able to find was the guy's hours of service. And as we looked at his hours of service, we could see that over the 8-day period before the incident, he was well over his 70-hour maximum that's capped by the DOT regulations. So we had a driver who was driving fatigued. So now not only do we have a compelling case of how the driver was negligent and the company was negligent for not ensuring the drivers stayed within their hours of service, but we also had a compelling explanation for why the truck driver wasn't a very reliable narrator about what had happened, because fatigue, as we know, can cause significant amounts of impairment. Anybody that's been on a really long road trip can tell you that driving after a while gets fatiguing, and it starts to limit your reaction time and your reflexes. It can start to affect your decision making, and you'll just start making mistakes that you wouldn't make if you were rested. So when drivers are driving fatigued, as they're not supposed to, and that the regulations exist to try to prevent it from happening, but something like that can just completely break open a case. We had a case very recently where just discovering the cell phone records made the case go from one where they were offering a few $100,000 to over $1 million. These things make a really big difference in the outcome of the case. And another thing that I think is pretty interesting is sleep apnea, specifically. Like the Department of Transportation's annual physical examination contains a requirement that the person have their breathing and sleep tested. And so if somebody has an obstructive sleep apnea diagnosis, they're required to use a CPAP machine as treatment if they're going to be doing any kind of over-the-road trucking. So we want to do investigation into whether drivers have sleep apnea, if they're using their CPAP, and they have a CPAP card that actually shows that they're using it. So we look for stuff like that, because driver fatigue is a huge factor, because that's one of the biggest differences between truck drivers and regular drivers on the road. Is just truck drivers are putting a lot of hours into driving. So they're a lot more likely to be in kind of a fatigued state when they're driving.
Yeah, I've heard that, unfortunately. Let me ask you, staying on your area of practice and your years of doing this, what are some of the biggest challenges you've seen attorneys often maybe underestimate when they first encounter a trucking case like this, especially if the injuries are severe or maybe the liability picture is a little bit more complicated?
Yeah, I'm going to get a little bit inside baseball with you on this too. I'm going to kind of get a little more nerdy on this one. So, there's a bunch of things that are kind of, to me, red flags for cases that are going to end up getting litigated, and also could potentially create problems for lawyers who may not do as many 18-wheeler cases that are trying to do them in-house while kind of avoiding litigation. So The first thing that I would say is that you're going to end up litigating one of these cases if you have a liability denial, or you have a trucking company that is stonewalling or delaying heavily a decision about whether or not to fix vehicles. So if you've got a straight up liability denial, that's getting litigated. If you have a company that's dragging its heels on property damage, is probably trying to avoid making a liability determination, potentially pending an ongoing investigation where they're trying to work up some kind of defense. So those things will typically mean a case will end up getting litigated. I would say that one thing you got to understand about truck drivers is that truck drivers are much less likely than an average person to admit that a crash was their fault, even if it obviously was. So, we do see plenty of drivers who are just driving, regular private automobiles, who get into crashes, who will vehemently deny that it's their fault, even if it clearly was. But with truck drivers, it's like almost all the time. Like it's very, very uncommon to see a truck driver who will admit that something was their fault even a little bit. So when we see a crash report that's inconclusive, that's usually an indicator that the case is going to have to be litigated, because they will typically use whatever they have to try to claim that it wasn't their fault. Also, the presence of multiple other vehicles. So if it's a somewhat complex case, like let's say there's 3 or 4 vehicles involved, or God forbid, multiple 18-wheelers involved, generally that might be a case where you would need to consider not only litigating it, but hiring an accident reconstructionist to make sure that you were able to prove what really happened in the case. So those are examples of cases where it's a lot more likely that the case is going to be complicated or need to be litigated. I would also say that another area where I think lawyers can get in trouble if they're not really used to litigating this type of case, or they're not really used to negotiating in this kind of case, is if their damages that they're claiming are, let's say, 1/3 of the size of the policy or less. So you've got $1 million policy. Let's say your economic damages are $300,000. If you're trying to negotiate pre-suit, I think a lot of lawyers can get stuck, getting lowballed. Because remember, like I said a little while ago, with these big policies, particularly big policies being paid by an entire fleet, there's a lot of premiums that are going in, which means there's a lot of house money to defend the cases. So there's more money to pay defense lawyers, pay experts. And the longer the insurance company can delay paying the claim, the better it usually is for them, which is why we need to use a very strategic sense of timing and leverage to try to get them to pay timely, as opposed to just drag their heels indefinitely. But if a case is kind of not a small case per se, but small relative to the size of the policy, lawyers can kind of get stuck being lowballed if they're not willing to litigate, because even if it sounds like a lot of money, $300,000 out of $1 million, 300,000 still sounds like a lot of money, right? But it's not relative to the limit. So, when you're in that spot, it can get easy to get stuck where they're offering, 150 or 200 and make you litigate. Like I've been saying for many years, the insurance companies know who's trying cases and who's not. And if they think that you're not, they think that they can lowball you easier and that there's nothing you can really do about it. So those are a couple of the ways that I think that these cases can end up getting stuck. Also, last thing I want to mention, and this is especially technical, but diminishing limits policies or eroding policies. We see eroding policies a lot more with commercial auto cases. And what that means is that there's a comprehensive limit of liability, and every dollar that the insurance company pays out, whether it's on property damage or bodily injuries, actually shrinks the limit. So you could have an eroding policy, and they'll never send you a copy of the policy unless you sue them. Let's say they've paid out $20,000 in property damage. That means there's $980,000 left. If you send them a Stowers letter for $1 million, that's invalid because they don't have $1 million. The limit is eroded to $980,000. And so they can hang their hat on those technicalities and kick the can down the road for quite some time until somebody figures it out or you end up in trial. So those are the kind of things that can really matter in these cases.
Yeah. Well, I love a good inside baseball reference, so I definitely get that. And I love you diving deeper into the weeds. So let me ask you, as we put a bow on today's episode, in your experience, where do these cases tend to break down for attorneys who don't regularly handle cases like this? And what should they be alert to before the case progresses a little too far?
Yeah, I mean, the answer is actually a little bit subtle because I think that a lot of the time, if you're not litigating a lot of 18 wheeler cases or commercial auto cases in general, um, it can kind of be something you don't even notice because you're not accustomed to the value that they'll put on things when there's really significant exposure. And so, the settlements look bigger relative to your $30,000 and $50,000 cases. So it can be easy to kind of not even notice that you're being handed the short end of the stick. So it can break down almost like without the lawyer noticing it if they're not too experienced with these kind of cases. So the kind of knowing how to evaluate them properly kind of requires a plaintiff attorney that knows how to do it. So if they're not as accustomed to it, then I would encourage them to contact somebody like me, but you can contact whoever you want, obviously, about these things. But I can give you an opinion about what the case could be worth, and it may be considerably more than what you were thinking of. And also, they can just break down because the discovery that gets done on the case, if it's filed, if it's not worked up diligently, I mean, it can break down just with having a defendant object to every single written discovery request that you send. You have to file the motions to compel. They will hide documents. Like, you have to they're going to make you work for everything that you get. So you have to file those motions to compel. You have to do the digging. You have to notice the corporate rep deposition. These are all the things that need to be done because they're not just going to hand you the smoking gun. You're going to have to dig for it. So, if you're kind of in car wreck mode where, we'll take the 2 depositions and then we'll try to settle it, it's not going to work because they're going to stonewall you. And there's going to be a lot of evidence, like in that second and third dimension of these cases, like I mentioned earlier, that you're not going to get unless you actually push for it. So that's one way it can break down. And another way that it can break down is just the cases can get long in the tooth. They can get to be, about to trial and they haven't settled because they've never put enough risk on it because it hasn't been worked up properly. So it's really important, I think, to get these cases into the right hands relatively early. Certainly once litigation is being contemplated, so that it can be a situation where the case is being, aggressively worked up by somebody that knows what to look for.
Kiernan, I can't thank you enough for the time, the insights, taking us under the hood here with all of this. Truly appreciate it, my friend.
You bet. Anytime.
That wraps up today's episode of Limits Exhausted, the Texas Injury Litigation Podcast. If you want to learn more about the work that Kiernan and his team do me a favor, visit McAlpineLaw.com, McAlpine law.com. Thank you to everyone again for listening. But before you go, do me a favor, hit like, subscribe, leave a review and comment, or share the episode with someone who needs to hear it. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.